we're opening in 10 minutes. I mean, it'd be something if they if she said that to them this morning, you know, 5 days ago. And not to mention, we've been here together for many of those 5 days. Well, I don't know, maybe there's a storm and all, but, you know, we were here together all day together yesterday. I mean, anyway. So that's the remedy I'm asking for. I'm not asking to delay opening. I'm not asking to delay the trial. But at the very least, they should not be able to call her until Tuesday to, out of fairness, give us time to deal with this.
Mr. Garner?
Yes, Your Honor. So the state does conduct pretrial interviews with witnesses regularly. In our experience, oftentimes when you do that pretrial interview, things come up. Originally, when this statement was made, it didn't trigger anything in my mind that would be substantively different than her original statement to the police. And the part of that original statement was where she described the part of the trail where this happened. The order of events Mr. Otake gave is not exactly what she said in her statement. So this was consistent with that order of events in that she was trying to get past the defendant on that narrow section of the trail. And what I understood this statement to be was just be an explanation, a further explanation of how she was getting past the defendant before he grabbed her. So that was my understanding of how it was similar or contained in her other statements. I was reviewing all the transcripts yesterday. I discussed with supervisor late last night and came to the conclusion, in abundance of caution, we should disclose this. So we did. It is not inconsistent with any of her other statements. It is an additional fact, an additional thing she told the defendant, an additional fact, but it's not something that makes whatever else she said not true. So it's not on its face inconsistent. It's not on its face exculpatory. I understand that defense will want to use it to impeach her just on the fact that the statement was not made prior. I understand that. But there was no malice or ill will with that. It was just, it came out in the interview. It didn't even cross my mind as something that was new to the point that it needed to be explained. I thought it was just essentially an explanation of something we already all knew. So that's the background on that one. I want to note that Mr. Otake mentioned he might need to subpoena Mr. Kuliole. He is already subpoenaed by the defense. So that witness has already been subpoenaed by the defense and I believe was in contact with the defense team. Lastly, the remedy that the defense asked for. My understanding of how the schedule would be working tomorrow would be the plan is to call Ms. Konig in the early afternoon, finish the direct, have approximately an hour for cross-examination to start on Friday, and then for cross-examination to continue on Tuesday. So I believe that we should still be able to put Ms. Konig on. There will still be opportunity to start the cross-examination. Defense will still have the weekend to discuss and use this disclosure. Overall, every time you interview a witness, there's always a chance that something comes up. This is one that didn't, when it happened, strike me as something that needed to be disclosed. After further reflection and abundance of caution, we did. But that's the situation here. Thank you.
Thank you.
Just very briefly, I mean, obviously, the fact that they felt the need to talk to a supervisor about it shows that, you know, it was something that was on their mind. And let me just say how I think this played out, logically in their mind, right? They withheld it for 4 days, right? She's testifying, I don't know, tomorrow, supposedly, and it occurred to them that she was probably going to say this on the stand. And it occurred to them that, and I was going to say, you never said that ever before in 4 interviews with the detectives, grand jury testimony 252. You never said that before. And then it occurred to them, her response was gonna be, well, yeah, I did, I told the prosecutors that last week. And then they would be in trouble. So I think that's what happened when they're like, oh, it's not an abundance of caution to help us. It's because they realized that this was gonna lead to big problems. So and the remedy of letting her do her direct tomorrow afternoon and we don't cross her to Tuesday, that's worse for us. That's not a remedy at all. That means, so that rewards them for this misconduct. So she should not take the stand until Tuesday to give us a chance to evaluate this, figure out how we want to use it in our cross, be ready to go as we listen to her direct, have time to talk to my client about it. And it's the least we can ask for and do under these circumstances, which, I know we're opening in a few minutes, and so it is what it is, but it's the least that we can ask for. I don't know. Anyway.
Anybody want to add anything else?
Just, no.
Okay. Counsel, appreciate your thoughts. The court, I'm not clear on the true impact of these new statements of the complaining witness might be. And I don't think I need to get into it at this point in time. What I will do, though, given the situation that we're in, and to preserve our ability to proceed, I'm going to grant Mr. Otake's request to delay the presentation of Arielle Konig's testimony until next week. It doesn't sound like it's going to set us back that much in terms of trial, and it will give Mr. Otake and the defense team the opportunity to fully consider what might have been turned over recently, and we'll just start with her testimony on Tuesday. I
Thank
think
you,
that's
Your
a
Honor.
reasonable request.
Thank you.
Anything else we should take up before we have the jury come back in?
I do have some concerns with some of the defense exhibits. I brought this up, and I would be listing those concerns for the court.
Do we need to address that right now before closing? Or,
We'll
before
address it
opening?
before, I want to address it before any HPD witnesses testify.
Sure.
Were you going to use those exhibits?
I don't know which ones he's talking about.
These are the body counts.
Well, with the witnesses today, there may be, but there's certain, and we can get into it exhibit by exhibit, but as a whole, there's some clips we made that don't have audio, just to show, because it's the best evidence of the trail when the officer's walking up the trail. So there's that. There's other clips we made, but so I'm not sure which ones or which officers, but is your concern that we're gonna?
What is the concern?
Yeah, what's the concern?
The concern is that the body-worn camera of several officers is clipped to specifically show officers discussing the legal charges that they're considering, and essentially introducing opinion testimony of the officers about the appropriateness of any charge, which in our mind is not admissible. And they've been clipped to not even include the full discussions of the officers about the charge. So that's the concern.
Well, isn't any statement on the body cam an out-of-court statement that's hearsay?
So if I can explain.
Yeah, not admissible.
We're not,
unless
it's impeachment. So we have it there as an abundance of caution as impeachment, at least those clips. So, my plan was to ask the officers certain things about those things, and if we need to, it's impeachment. I'm not planning to admit that. I agree with you generally that statements on body cams are hearsay, and unless there's a non-hearsay good reason for it, but I viewed it more as impeachment. I put it in there just in case. I'm not planning to admit them into evidence.
and the impeachment doesn't go to their legal opinion as to what the appropriateness of the charge is.
Yes, but just,
Yes, it doesn't, or yes, it does.
yes, I agree with you. But I think what he's getting at, and again, I don't think we need to address that right now, but what he's getting at is there are some clips where the case gets classified as an assault second. And then the one officer is discussing it with, I think he would maybe the sergeant, and the sergeant's like, "Oh, that sounds bad. Let's make it an attempted murder." And he's like, "Okay." And so, I mean, that's it. Just to show how it got reclassified. But I don't know if we need to address that right this second. But I think that's what he's concerned about, right?
And that is a very serious concern.
It is, because their legal opinion as to what the classification of the charge is not relevant, right?
Yeah, right. But their full and fair investigation is. Full and fair investigation is always relevant, and the fact that within 5 minutes they decided that this was going to be an attempted murder is highly relevant to their lack of a full and fair investigation before that decision was made. And what information did they have when they classified it that way or reclassified it from an assault to? They see her, they deal with her, they say this is assault 2. She gives some statements. They just take that statement, and 5 minutes later he's arrested for. I mean, it's upgraded to attempted murder. So that goes to their full and fair investigation or lack thereof. So it's not a legal opinion. It's
these are scene officers, not CID or not investigators that actually confirm the case, right?
Well,
these are patrol guys.
Yes.
There is a patrol officer, a sergeant, and then they are at some point in touch with the detective.
Okay, I understand. I'm inclined to keep out their conclusion as to what the appropriateness of the charge is. But we can also address it later if we need to, but that's my general thought.
Understood.
Anything else we should take up?
Not for the moment.
I know we said 45 for opening, but that sounds like a little flexible.
Yesterday.
Huh?
You said 40
No, 40 was for deer. 45 was opening. Oh,
Okay.
that's like 40 was for deer, because remember you asked him, are you good?
That's fine.
I would have never said 40. There's no way I can do it in 40.
Okay, but you had a concern about that, Mr. Otake?
Just that if it leads into 46, 47, it's not the end of the world.
That's fine. And can we agree, though, that we keep them together?
That's okay with me. I don't know if for a court report, if that's okay, and
I
as
think
long as nobody use their I mean, I prefer that, but
I think that's what we should try to do if we can. Anything else we should take up?
Just in the goal of that, would it be best then to take I know the court's instruction is not super long, but would it be best to take a break after the court's instructions? No?
The instructions are 5 minutes. 7.
you're gonna hold the stop sign after 5 minutes.
That's good for you. Anything else we should take up?
Nothing else for this moment.
Okay.
Thank you, Your Honor.
Let's recess for now.
Gentlemen of the jury, Deputy Prosecuting Attorney Joel Garner for the state. Also present is Deputy Prosecuting Attorney Franklin Don Picaro, Jr.
Morning, Mr. Garner. Morning, Mr. Picaro.
Morning, Judge.
Good morning, Your Honor. Good morning, ladies and gentlemen. Thomas Otake and Ma Dirks on behalf of Dr. Gerhardt Konig, who is present.
Morning, Mr. Otake. Morning, Mr. Dirks. Morning, Dr. Konig.
Morning, Your Honor.
Gentlemen, all of you can be seated. Ladies and gentlemen of the jury, good morning to all of you. Welcome back to courtroom 15. Thanks for your patience. I should have told you when we were selecting our jury the past couple of days that there are always delays here in circuit court. I think you're already aware of that. So thank you very much for your patience. We try to keep the delays to a minimum, but there are always delays, so thank you for your patience. Now that we are gathered back here in courtroom 15, I have some preliminary instructions before we proceed on to opening statements by the attorneys. Keep in mind that the charging document, the indictment that I read yesterday, it's not to be considered as any evidence against the defendant. It's a mere formal charge that's necessary to begin the trial. The defendant, under the law as we discussed yesterday, is presumed innocent of the charge, and this presumption remains with the defendant throughout the trial unless the evidence in this case has satisfied you beyond the reasonable doubt of the defendant's guilt. The burden of proving the defendant guilty beyond the reasonable doubt is on the prosecution, and the law does not require the defendant to prove his innocence. Let's talk about the order of proceedings. As I indicated, each lawyer will have the opportunity to give you an opening statement. An opening statement is a preview of what each party expects the evidence will show in this case. Prosecution will begin with its opening statement and then followed by the defense. Once we're done with the opening statements, at least for this morning, we'll take a break and we'll come back after the recess. The prosecution has the opportunity to present its case in chief. So they'll be calling witnesses to come and testify from the witness stand, and introduce and display any physical items that may be received into evidence. After the prosecution presents its case in chief, the defense may choose to present a case, but they're not required to do so. And if the defense presents evidence in this case, the prosecution, in some limited circumstances, will have another opportunity to present what's called rebuttal evidence. After all of the witnesses have testified in this case, I'll then instruct you on the law that you must follow and apply in this case. After you've been given those legal instructions, the attorneys will then have the opportunity to give final arguments to you, where they talk about what facts have or have not been proven by the evidence. The prosecution will go first with its closing argument, followed by the defense. And because the prosecution has the burden of proof, they have the opportunity for what's called rebuttal closing argument. After all of the arguments, you will be conducted into the jury deliberation room to begin your consideration of the case. So that's the flow of what trial is going to look like over the next couple of weeks. As the judge in this case, I have three main duties. Number one, I'll make sure that the court proceedings are kept orderly. Number two, I'll determine what evidence can be received during this trial. And then number three, I'll provide you with the legal instructions or the law that you must follow in this case. You, ladies and gentlemen of the jury, you will be the judges of the facts. You will decide what facts have been proven by the evidence. And a very important part of your job will be deciding whether a witness is truthful, whether their testimony is accurate, and how much weight or importance to give to their testimony. All of the evidence in this case will come in the form of sworn testimony of witnesses and any physical items that are received into evidence. So now let's talk about what's not evidence. A question asked by a lawyer is not evidence. You will hear the attorneys make objections during trial. Those objections are not evidence. All of the questions and answers that we've been going through during jury selection, not evidence. The opening statements and the closing arguments by the lawyers are also not evidence. Sometimes you'll hear a witness testify, and I may strike some of the testimony. Any testimony that I strike, not evidence, and you cannot consider the stricken testimony when you decide the case. And speaking of objections, you will hear lawyers make objections. It's their duty to object when they believe it's appropriate. And those objections are helpful for the court to make sure that we remain focused on the issues that the jury needs to decide. I'm going to rule on those objections according to the law. When I rule on those objections, don't be concerned about my reasons for the rulings. If I sustain an objection and I do not allow a question to be answered, you must not speculate about what the answer might have been, nor draw any conclusion from the question itself, because an unanswered question is not evidence. You will see me meet with the attorneys up here at the bench. We'll turn on the white noise. We'll have a whispered conference. We do that time to time. We need to discuss certain legal matters as the trial unfolds. If it's going to be a longer discussion, what I'll do is I'll just put the jury on recess, have you wait outside while I conduct that longer legal discussion in the court with the attorneys. When we do have those bench conferences or when we do have those recess conferences, don't speculate about why we're meeting, and pardon the inconvenience when we do have them. Notes. This is a long trial. Each of you will be given a notebook, or notebooks if you need more, and pens. Now, some jurors prefer to take notes as the evidence is being presented. Other jurors prefer not to do so. It's up to you to decide whether or not you want to take notes. Keep in mind, though, your notes are not evidence, and they're only a memory aid for yourself. They're not a substitute for your own recollection of the evidence. If you do take notes, though, make sure that you can still listen carefully to all of the testimony and observe the witnesses as they testify. Your observations of a witness may be considered when you're determining credibility. Whenever you leave the courtroom, leave your notebooks face down on your chair. They'll be waiting for you the next day you come back to court. Your notes will not be read by anyone. When you begin your deliberations, though, you're able to take your notes with you into the jury deliberation room. During this trial, do not talk about this case with anyone. That includes friends, co-workers, or family members. Don't allow anyone to discuss this case with you. And if anybody asks, tell them that you're under court orders to not discuss the case. Throughout the course of this trial, even when we recess at the end of the day, do not share any information, opinions, or anything else about this case with anyone. personally or through writing, digital communications, or social media. You must not discuss this case, even amongst yourselves, until you are instructed to begin your deliberations. And during your deliberations, you can only discuss this case in the jury room when all jurors are present. Do not investigate this case in any way. This means that you must not visit any of the places that are mentioned during the trial. You cannot conduct experiments, consult any reference materials. Do not read, listen, or watch to any media accounts about this case. And again, there are media accounts about this case. Don't try to look it up. Don't research it. If it happens to show up when you're eating dinner, turn off the TV, walk to the next room. Again, your decision must be based on the evidence that's presented here in the courtroom, as well as the court's instruction on the law. If you do receive outside information, though, even if it's unintentional, do not share it with any other juror. If that happens, or if anybody tries to influence you during this trial, you must immediately tell Ms. McCallum. Keep an open mind throughout this trial, and do not make up your mind about the verdict or about any other issue until you have discussed this case with the other jurors during deliberations. Also, do not conclude from my rulings or anything else that I say or do that I favor one side over the other. And as we discussed during jury selection, do not let any bias, sympathy, prejudice, or public opinion influence you during this trial. And my last instruction is, make sure you keep all your electronic devices on silent mode while we're here in the courtroom. We will give you, if you don't already have it, if anybody needs to get a hold of you, they can call the number. We'll get the message to you as soon as possible. Before we get to the opening statements, Ms. Tony Fisher is now the clerk taking care of the administrative duties today. As I indicated, she and Ms. Long will be taking turns here in the courtroom. New court reporter today, this is Ms. Nikki Chang. She's taking Ms. Miyasato's place. The court reporters will also rotate during this trial. So ladies and gentlemen, we'll now get to the opening statements of the attorneys. The purpose of an opening statement is to give you an outline of the evidence that each party expects to be presented in this case. Essentially, it's a preview of the trial as seen by that party. It is not evidence, but merely intended to help you in considering the evidence. Prosecution will go first, followed by the defense. Mr. Garner, are you ready to present the state's opening statement?
Yes, Your Honor.
Please.